Hello, my name is Jonathan Edwards. I'm a barrister at Radcliffe Chambers. I specialise in a number of chancery areas of law, including disputed wills and estates. And today I'm going to be speaking to you for about 30 minutes on various problems which arise with wills. I'm going to be focusing here not on challenges to wills for things like lack of testamentary capacity or problems of interpreting wills, but some of the other kinds of problems that can arise. And so, without further ado, I'll begin with some starting principles so we know where we are. It's surprisingly tricky to come up with a neat definition of what exactly a will is. But I suggest there's a reasonable definition for most purposes. A person's will is those statements by that person of their testamentary intentions which are recognised by the probate court as legally effective. And so, of course, normally we imagine a will as being a single written document formally executed, or possibly an original single written document followed up by a number of codicils. However, what we'll be addressing today is some of the more difficult cases that can arise. And I think it's important to take as a starting point that paradigm example of a single formal document is not the only thing we're looking for. And so, for example, in the old case of Le Marge and Goodban, there was more than one document, both validly executed. And the point the court made was that you can't say that the later one automatically revokes the earlier one. If it doesn't say it does that. Instead, you've got multiple testamentary documents, and you have to read them together, even if there are some inconsistencies or repetition between them. Another point I'll therefore make is that quite a lot of the problems we'll be looking at can't be solved simply by looking at a document and seeing the answer. Quite often, there's no way of avoiding the real issue, which is a factual issue. So moving on to the question of how a will is made. Of course, the overwhelming situation is that you need a will that's executed as a document in accordance with Section 9 of the Wills Act 1837. And for most of the rest of the talk, I'll be assuming that we're looking at documents of that kind. But it's worth remembering that there are exceptions. You can have an informal or even entirely oral will if it's a privileged will. And that's essentially wills made by soldiers and sailors.